that deal with the matter of Canada Goose UK Hotel Limited as another and persons unknown.
Good morning, my lords. You should each have a small second supplementary bundle of authorities, which has at the front, before tab 1, an analysis of case law table in which I have tried to summarise the most recent 10 years of final quia timet injunction case law references. Some of them are actually in interim injunction cases, but relevant principles are discussed. Most of those cases appear in that clip. I don't think it will be necessary to take you to all of them, but I'm hoping that that will provide a sort of ready reference point for you on specific points, and I will be going to a couple of those authorities specifically. The way I propose to deal with matters this morning is that I have basically 6 points. The first picks up directly where we left matters yesterday afternoon, and I want to talk about whether final injunctions in general only bind those against whom they're made, or whether they can be made contra mundum in this specific context. Secondly, I want to look at the case of Astellas in 2011, which is the closest that this court gets to considering these issues, albeit it arises in the context of a Rule 19.6 representative defendant, but deals with the issue of whether a final injunction is simply binding on third parties or can be made enforceable. But that's the closest that this court gets to these issues. The third point is to...
That's a protester's case, is it?
Yes, it is.
Yeah.
Yes, it's another Huntingdon case.
Right, yeah.
The third point is to look very briefly at those first instant cases where final quia timet injunctions against unknown third parties have been granted, and whether in fact those can be said to be rightly decided or not. Fourthly, I want to look very briefly at the point my Lord Justice Richards raised yesterday about contra mundum injunctions in the confidence context, and specifically the Venables jurisdiction.
Can we develop some sort of English phraseology for this? I mean, people will be live streamed.
Against all the world?
Everyone?
Everyone would do.
I thought that would be perfectly acceptable.
And finally, there is a recent decision of Mr. Justice Warby from November 2019 called Birmingham versus Afsar, in which precisely this issue is considered, and that was another protest case about sex education at a specific school in Birmingham, and protesters outside it. And lastly, I'll just mop up any issues from the list of issues that I was originally presented with that I don't think I've covered in the earlier 5 points.
I must have missed out one. I've got 5, but never mind. One slipped through. It's okay.
Point 1 then, my lords. The nature of final injunctions in general. My starting point in researching this last night was, I'm afraid, a Google search. And that turned up the report that you'll see at tab 3 of the supplementary bundle, which is the report of the Master of the Rolls' Committee on Super Injunctions from May 2011.
Lord Newburn.
Indeed, Lord. On super injunctions, anonymised injunctions and open justice. It's 147 pages long, but I've just presented you with one small section. And in discussing the recent increase in anonymous proceedings being ordered, the committee addressed firstly at paragraph 2.2 the distinctions between interim injunctions and final injunctions. And in paragraph 2.2 and 2.3, it makes clear that a super injunction is a form of interim injunction. So much is uncontroversial. Over the page at 2.6, a specific characteristic is noted of those super injunctions, that as a form of interim injunction, it not only binds those against whom it's issued, but also any third parties who have notice of the injunction under what is known as the spy catcher principle. And I'll come back to exactly what the spy catcher principle is in a moment. 2.6 continues, third parties served with copies of such an injunction are, under this principle, subject to the court's contempt jurisdiction, the aim of which is to protect the court's process against acts and words tending to obstruct the administration of justice. And the footnote, not that footnote, in fact, let's go on to paragraph 2.7, where the contrast is made with a final injunction, e.g. one made at trial following the final determination of the party's substantive rights, only binds those against whom it is made. Once proceedings are concluded, or in the meantime, if it has lapsed by the expiry of a time limit or is set aside, like any other interim injunction, a super injunction ceases to have any effect and therefore no longer binds any third party who has notice of it. So there is a specific statement that final injunctions do not have binding effect against third parties. And the authority cited by that committee for that proposition in 2.7 is in footnote 67, Jockey Club versus Buffum. And that case is at tab 2 of the new authorities bundle. Buffum was a case in 2002 in which Mr. Justice Warby, in his former incarnation, represented the Jockey Club in an action in which a restrictive covenant had been imposed in a termination agreement between Mr. Buffum, who had been head of security at the Jockey Club, and the Jockey Club. And an order had been granted. We just turn up paragraph 4. Paragraph 4 sets out the restrictive covenant that ultimately was sought to be enforced, not to divulge any trade secret or confidential information concerning the business or finances of the Jockey Club. Between C and D, it was also agreed between the parties that Mr. Buffum would return to the Jockey Club all documents he retained relating to the business of the Jockey Club. But he didn't do that. He retained some documents. The Jockey Club became concerned that he'd done so and sought to get him to surrender them. So proceedings were commenced by the Jockey Club against him to enforce that covenant. In paragraph 7, we can see the proceedings were ultimately compromised by consent, and an order was made providing that the defendant must not, without the claimant's prior written consent, do any of the following acts, including divulging to any person trade secrets or confidential information. That order, in paragraph 7, the end of paragraph 7 on page 466, also provided that any person other than the defendant who was served or given notice of this judgment might apply to the court to vary or discharge it, and the order was served on the BBC. It was served on the BBC because the Jockey Club were aware that Mr. Buffum had been talking to the producers of a Panorama programme about corruption in racing. Now, Mr. Buffum continued to want to deal with Panorama, and the BBC quite properly asked the Jockey Club for permission to use some of its documents that Mr. Buffum had given them. They gave permission for some of them, but not all of them. And when the BBC wished to rely on them anyway, the Jockey Club brought this application to enforce the order against the BBC. So this is an application by a third party, well, by the Jockey Club to enforce a final injunction against a third party. And the way that the Jockey Club sought to do that is set out at paragraph 20, which was by means of the spy-catcher doctrine. And the way that Mark Warby put it for the Jockey Club in paragraph 20 was that the BBC, having notice of the order against Mr. Buffon, would be guilty of contempt of court if it were to perform an act which undermined the purpose of the order in reliance on spy-catcher. Against that, it was said, paragraph 21, that spy-catcher only applied to interim injunctions and had no application here. Now, over the page at 23, Mr. Justice Gray discusses those contentions and says that there's no binding authority on the point. He concludes that the spy-catcher principle only applied to interim injunctions and not to final injunctions. And he bases that, in paragraph 24, on the reasoning of Lord Phillips in Attorney General in versus Punch in 2001. And the critical part of Lord Phillips' reasoning is set out at page 469F, para 86 of the Punch judgment, where he cites the established principle of English law that an injunction does not bind a third party, a principle acknowledged by both the Court of Appeal and the House of Lords in the spy-catcher contempt cases. And for that reason, the House of Lords cannot support a principle of that width, the principle being that any third party with knowledge of an injunction who intentionally destroys the claimant's right thereby interferes with the end of justice and commits a contempt of court. Now, this case also considered the Venables jurisdiction at paragraph 20 and acknowledges, paragraph 26, I'm afraid, in the second half of that paragraph, and acknowledges that in the context of a protective jurisdiction of the court, as in Venables, the court can make an injunction against everyone. But that was not the case here. Midway through paragraph 26, my lord, it appears to me to be implicit in Mr. Warby's argument.
Includes the dreaded words contra mundum.
Which I conscientiously avoided.
Well done, very good. So I'm just trying to understand. So he rejects the idea that you can have such an injunction. Is that right?
He acknowledges that you can do it in the specific context of a confidence action with a protective jurisdiction like Venables, but says that you can't read that across to a case like Buffon, where those exceptional circumstances don't arise.
How, as a matter of interest, how do you frame such an injunction against the world, against everyone? In the way you can do. How are they framed?
I think they're normally framed against publication of, and then the information to be protected is described.
But it's still against a part, but it's an injunction against someone. Who's an injunction against?
You will have still a named defendant. So in Venables it was News Group Limited who remained the named defendants. But there is no direction in the order, so far as I can see from the Venables report, as to who it's directed to. It's just publication will catch anyone. Well, I'll take you to the Venables report.
Well,
but
I don't think more time is
there.
necessary. But is it a matter of judicial interpretation that although it's in such a case, the Venables case, protective jurisdiction, whatever that is, but in such a case you interpret it as an injunction against everyone, even though it's actually a direct. I mean, you must enjoin somebody.
Yes, my lord, I think that has to be the case. There's no specific reference to it being against everyone.
But I mean, it is granted intending to be against everyone. So, I mean, that's the nature of the injunction. There's no doubt that that is the intention.
No, that's right, my lord.
The crucial point about Venables is that I think it's the first time that such an injunction has been granted in respect of an adult. I think all the previous injunctions of these types were granted as part of the exercise of the court's wardship jurisdiction. And the important point, there was a prior injunction in respect of Venables and Thompson while they were minors. But the new point was, well, could you grant such an injunction outside the wardship jurisdiction? And Dame Elizabeth Butler Sloss in the Venables case says, yes, you can, as a means of giving effect to the European Convention on Human Rights as domesticated by the Human Rights Act. And that is accepted as the correct approach by Lord Stayne in a case called Reed, where he said that this is permissible by way of giving effect to the Human Rights Act or the Convention rights.
My lord, that's right, and I've included at where is it? Tab 8 in that clip, the 2019 judgment by Sir Andrew Macfarlane, in which there was an application.
This is the most recent.
This is the most recent Venables case, in which there's a review of the history of that injunction from Dame Elizabeth Butler Sloss onwards.
Does it say in it, just a matter of interest, can you direct me to what the form of the injunction? Is it in this case?
No, it's not, my lord. I mean,
I assume, therefore, the order is, as you say, something along the lines of, there shall not be published X.
The closest it gets, I mean, there's a description of the type of material that may not be published, and that's in that particular report.
It's at 2, is it?
It's at 2, my lord,
A1C.
exactly.
Yeah.
But there's nothing there describing who it binds. So I think my lords are right, and you have to read into it that it's intended to be against anybody by the nature of the act of publication. Publication could be by anyone, and it's not specified that it's by a specific newspaper.
Anyway, all right. So that's the first point. Yes. So is that deal with your point 1?
That's point 1.
Right. Thank you.
So the spycatcher principle does not apply to final injunctions. You can't bind third parties that way,
Except in this protective.
except in the Venables sense.
So-called protective area.
Yes, and that protective is used it originates from the wardship jurisdiction that my Lord Richards averted to. That's where that term comes from. So the second point was the closest that this court gets to dealing with these issues so far as my learned friends and I can work out, which is actually a case in the original authorities bundle at tab 13 called Astellas from 2011.
Before we start on this, just so that I can vocalise the different categories of case. So there are cases where, as in Canada itself, I suppose, there's a person who is identifiable and exists, but you don't know their name. And in the squatter cases, that's the sort of people we're talking about.
Yes, my lord.
In terms of final order for possession or what it may be an injunction, they're all identifiable, but you don't know their names.
Exactly.
And they're identifiable in relation to something which has happened. There are people in occupation, and you want an order of possession against them. Or in the case of the gypsies, which were moving or might move from one place to another. That's the Lady Hale's case. So looking at that, it was an injunction against those people moving across.
Yes.
So in all those cases, I think, but I may be wrong, so these are very tentative comments, there's an identifiable group of people by reference to either they're in a particular place or they've done a particular thing, but you don't know who they are. And then, and so in a sense, looking at our case here, you can identify, even though you don't know their names, you may say everybody who has been involved in these protests. The complication arises in relation to a quiet time injunction, in relation to people who will only be identified by virtue of doing something in the future they haven't yet done.
By joining the protest in this case, exactly.
By joining the protest or
Exactly.
doing whatever it may be. Now, that problem doesn't normally arise in ordinary, I'm going to call it anticipatory, an anticipatory injunction, I can call it that. It's a bit of a misnomer. Because you can identify a particular person, and you say that particular person I can identify, I say is likely to do a prohibited and unlawful act, and therefore I'm entitled to this injunction. And it could be both an interim one and a final one.
Indeed.
So the complication, and the real issue, I think here, but again, others may disagree, is whether there is a difference in substance between that type of case and a type of case, I suppose, where you can have a quiet time against somebody, again, who you don't know who it is, but they definitely exist. So you could say, well, they are this particular person. I don't know who it is. It could be, I think I saw a case in relation to people who were, through the internet, harassing somebody. You couldn't identify them, but you knew they existed.
Yes.
So that's one step away from the person you actually know, but there's a person, you can't identify them, but they definitely exist.
Yes.
And then you get to a category of case, which is really where I think which we're involved with trying to deal with, which are more than one people. You can't identify them now, because they are only identifiable if they will do something.
Precisely.
But you don't know if they ever will.
No, they are. We've called them newcomers. Mr. Justice Nicklin called them newcomers. I've adopted that in my submissions.
Yes.
So newcomers to the protest, where in circumstances where you have a rolling body of people protesting against an issue, some of whom may come every day, some of whom may come once.
We know they exist. I mean,
And-
assuming the protests don't go so long that somebody's got a baby, it's going to become. Otherwise, we know there are people out there. So it will be one or more of people who exist.
Yes.
But we can't identify who they might be, not simply because we don't know their names, but we don't know whether they actually are going to be the person who will do this thing. And so the question is really whether that is a sufficient difference of substance to affect jurisdiction, procedure, practice. Is it permissible but unlikely to be granted? How far does Section 37 go? So I think that's what we're engaged in.
Exactly so, my lord. And obviously they transition into being Category 1 defendants, the identifiable defendants, as soon as they arrive at the protest.
Yes.
And then you can effect all the methods of service, both of the injunction and of the underlying proceedings in an interim context that we've discussed.
But you have to confront Lord Sumption's point.
But you have to, yes.
Which is, I mean, whether or not he's actually looking at this type of case is debatable. But his point, which is, yes, but those are people were never served before the order was made, so they were never ever a party to
Yes.
the proceedings.
Yes.
And the question is, are they comparable in substance to someone who simply was a party but didn't attend the hearing and then has all the rights to go back and to challenge it or appeal it, or are they substantively in a very different position, so actually they're completely outside the whole system, as it were, of adjudication?
Yes, and Mr. Justice Warby makes this point in the Birmingham case that came out in November. We could go there now, my lord, to see if actually.
No, you take your own course. I just wanted to articulate in
Yes.
my own way what I think the real issue is.
Yes, and he addresses that squarely. So I'll come back to that. He has one solution for it, but ultimately he declines to make a final injunction against protesters unknown of that newcomer group on the basis of Cameron. But that's the only application we found of the Cameron restraint since the judgment came out.
Okay, thank you.
Could I just add this to what my lord has said? So far as the first category that my lord identified, the effect of Cameron is that some defendants who would fall into that category we cannot get a final order against, I think. That is a question in a way. The point being that in Cameron, the defendant undoubtedly existed. It was the person who had driven the car, uninsured and so on, who had injured the claimant. So that person existed, but because they could not be served, the Supreme Court said that judgment couldn't be entered against them. So that within that first very broad category, it does subdivide between those against whom a final order can be made and those against whom it can't. Is that right?
Lord Sumption, in fact, calls it a separate category entirely. Category 1, and he uses this description if we turn it up, it's at, I think, paragraph 13 in Cameron, which is in the original authorities bundle at tab 17.
Paragraph
13, my lord.
13.
So the question Lord Sumption is addressing here is at the bottom of paragraph 12. The critical question is what, as a matter of law, is the basis of the court's jurisdiction over parties, and in what, if any, circumstances can jurisdiction be exercised on that basis against persons who cannot be named? Paragraph 13, necessary to distinguish two kinds of case in which the defendant cannot be named. The first category comprises anonymous defendants who are identifiable but whose names are unknown, and that's the squatter example. That's the Master of the Rolls example of category 1. The second category is Lord Justice Richard's category, defendants such as most hit and run drivers who are not only anonymous but can't even be identified. He doesn't say, but we know they exist, but that's implicit,
No.
obviously. They clearly exist,
Yes.
but there's no means of identifying them.
And then the reason he gives in the next sentence.
Exactly. In the first category, the defendant is described in a way that makes it possible in principle to locate or communicate with him. And that's because he's either going to turn up to a location or you can serve him by a website to which he's affiliated or some other means of that type. Whereas in the hit and run case, of course, the only route that they had to do it was either via DVLA or by the Motor Insurers Bureau, I think. But in the second category, that's impossible to communicate with them. And so in my submission, the newcomers are actually closer to this second category. Because until they turn up at the protest, it's impossible to locate or communicate with them, or to know whether they're going to be the same as the persons described as persons unknown in the claim form, to use Lord Sumption's words.
Well, not very impossible to communicate with them because, I mean, you could actually, in one way or another, through requirement for search, to notify all its members about what the prohibition is, about the proceedings. You could post things on social media. I mean, there are ways that you could tell basically everybody, who might like to turn up, that there are these proceedings, and this is what the court's doing.
It would have to be a very wide order for service, though, because...
Well, it's substitute service.
Yeah, for substituted service, because in the form that the appellants are seeking it, they want to catch, I think, Mrs. Smith from Penzance, who feels very strongly in her own right about these matters, but also surge activists, PETA, organised demonstrators. They want to catch everybody.
It's everybody who might want to commit to join the protest and commit an unlawful act. But what I'm saying is the advance of social media actually allows you to communicate with a vast population, which simply wouldn't have been possible in the past. And, the idea that with squatters you can attach the details of the writ to a stake is what one might describe as slightly antediluvian nowadays. I mean, yes, it's a very good way of doing it, and here the equivalent would be to put notices outside the shop so people could see them. But actually, all I'm saying is, I'm not saying it's an answer to the problem, but just to say you said you couldn't contact them, you couldn't warn them. I don't think that's in fact true. You could have an alternative form of service.
You can't guarantee contact with them. You can cast your net pretty widely, I agree.
But that's true, any alternative service is only a likelihood.
Apart from the fact that if you use alternative service by location and affixing to the vicinity of the store, you can pretty much guarantee it.
Yes.
And then but in all other cases, I suppose Mrs. Smith from Penzance is at liberty to come to the court and say, well, I don't use the internet, I don't look at Facebook pages.
She's an activist. I suspect the reality is that she's...
But the extreme case illustrates the breadth of what the appellants are trying to achieve.
I was mainly pointing... I'm
you
saying...
can certainly do much more
in this
than
day
I
and
ever could
age,
before.
that's all I'm trying to say. In this day and age,
And I agree
methods of
entirely.
alternative service are much, much greater than they were in the past because of technology. But that's all I'm saying, nothing more than that.
Quite right, and I think courts are increasingly taking notice of the means of affecting alternative service by those methods. It's just a question of quite how far you go to satisfy Lord Sumption's requirement of giving notice. Does that assist with the categorisation of
Very much
defendants?
So,
Going back then to Astellas at tab 13. This was a case in which there were 3 named organisations, of which only one is listed on the frontispiece, Stop Huntingdon Animal Cruelty. There were in fact 3 named organisations who were made representative defendants under Rule 19.6. And the case arose after a summary judgment had been given. This is paragraph 4. Summary judgment was given for the appellants, and the appellants sought an order restraining various persons identified in the draft submitted to the court as protesters from pursuing a course of conduct amounting to the harassment of various people described as protected persons. So in that respect, not dissimilar to the current facts. Since the action against Stop Huntingdon Animal Cruelty and the other organisation, Animal Liberation Front, was proceeding in a representative action, the appellants asked the judge to include in the order a paragraph directing that it be enforceable against all protesters as defined in it. The court's permission was necessary before it could be enforced against represented parties because Rule 19.64 provides that the court's permission is required for that. And the judge at paragraph 5 made the order in the very wide term sought, and to all intents and purposes imposed an exclusion zone, but he declined to give permission to enforce the order against all protesters because he considered it would be unjust to make an order against unidentified persons without giving them an opportunity to be heard and without giving some consideration to their individual circumstances. So the question was whether, under the umbrella of those representative organisations, the subheading of protesters, the injunction could be enforced against that subheading of protesters. And that definition was very wide, and it's set out at paragraph 14 in the judgment. included not only the defendants themselves and those acting in concert with them who had notice of the terms of the orders, but also any other person protesting against those issues, whether he or she has notice of the order or not. There was a side issue in the case about whether defendant in this context was the same as the defendant within the meaning of Section 3A of the Protection of Harassment Act, but I don't think we need to address that. Over the page at paragraph 17, Court of Appeal set out the first instance judge's reasons for refusing the permission, and he said the injunction is certainly binding on those who fall within the class of persons represented by the first defendant.
This is 17, do you say?
Yes, my lord, in the quotation.
Oh, yes, I see. Yes, thank you.
It may be that that enables such persons to be regarded as defendants for the purposes of the Act, the Protection from Harassment Act, and that an arrest may be regarded as not as part of the process of enforcement, but as preparation for that process. But it's not appropriate for me to determine whether or not the claimant's concerns can be met in this way, assuming a hypothetical case and without hearing submissions from the prosecuting authority and defendant in that prosecution. So that's the section 3A and 3.6 point. And paragraph 20, we have the Court of Appeal's conclusion that the first instance judge had had to balance the potential injustice to unidentified protesters of giving permission to enforce the orders against them, possibly by criminal process, without considering their individual circumstances. And the main sticking point was the extreme width of the order. And Lord Justice Morbitt concluded at the end of paragraph 20, in my view, the judge was entitled to reach the conclusion that it was not appropriate, or in the interests of justice, either to include in his order the additional paragraph sought by the appellants, or to give permission to enforce the order against persons who were unidentified at the time, and who might have not have become aware of its terms when they committed the acts which would amount to a breach of it. There is an interesting discussion by Lord Justice Ward at the end of the judgment, where he notes the issues that arise on this appeal and ruminates on them, but doesn't actually decide, doesn't actually give an answer to it. At paragraph 33, Lord Justice Ward says, I idly speculated during the course of argument whether the appellants would be better advised to seek to amend the claim to join persons unknown as defendants. There was some discussion about this, but the arguments were not fully developed. At paragraph 34, it seems to me to raise interesting questions, and then he cites Sir John Donaldson, Master of the Rolls, for the basic proposition, what is not permissible is to make an order against a stranger to an action, and that English courts act in personam. He then notes the exceptions to that rule that had been made in the Bloomsbury case and in the Hampshire Waste case. And at paragraph 35 notes that in dealing with this kind of issue, the court will have to consider the balance of ECHR rights at play. And he gives an example of a Canadian case, which I've not put in the bundle, but I have read, in which hundreds of people were blocking a bridge, and the safeguards incorporated there required that before the protesters were arrested, they were to be provided with a copy of the order and the terms of the order read to them. They were then given the opportunity to comply with the order, and only if they did not were they arrested. These cases show that difficult issues arise from seeking to join unknown defendants and to enforce injunctions against them. So all the relevant issues are canvassed, but it's all obiter and nothing resolved. But that, my lord, I think is the closest that this court gets to addressing the issues.
Well, Justice Ward doesn't there differentiate between interim and final in his discussions?
He doesn't, but the case itself was a final injunction.
Yeah, well, absolutely. The case there was a final injunction, so it was effectively the width of an order against a width of a final order, and hence potentially the relevance of being permissible to make an order against a stranger to the action. And of course both Bloomsbury and Hampshire Waste were, I think, interim.
They were. And the reason, the other reason I took your lordships to this case is that I wondered whether there was a distinction to be drawn in making a final injunction against the newcomers, whether you could distinguish it just being binding on them and making it enforceable, whether it might be permissible to name them as addressed by the injunction, but that actually to enforce it, to arrest someone outside Canada Goose, the appellants would have to come back to the court to do that. Now that seems to me terribly cumbersome and not likely to work in practice, but is a potential route to making that kind of order. But I'm not sure even that addresses squarely Lord Sumption's point, unless you adopt the example of that Canadian case and stop people and start reading out injunctions to them on the doorstep, which again is likely to be impractical.
I suspect the Canadian procedure must be rather different to our own. I mean, you can't, someone is breaching an injunction, you can't just arrest them. You have to commence committal proceedings, get a bench warrant from the court and so on.
They contained penal notices.
Yes,
Yeah,
but
so, but then you obviously
there isn't
you have
a
to.
power of arrest for breach of an order.
So that brings me to the third point, my lords, which is just to look briefly at the first instant cases in which this kind of injunction has been granted. We touched yesterday on the Vastint case, but I think we're all agreed that that was against there was a named defendant there, and I got the impression that my lords weren't keen to base their judgment on that example. The only other case I've found in which one was granted is a case from 2014 called Novartis, and again Huntingdon was the context, and that's at tab 4 of the new bundle.
This is Mrs. Justice McGowan.
Yes, my lord. It's not a very full judgment. And in brief, it is a summary judgment application, and it is an application for a final injunction against persons unknown flowing from that, which was granted. But there are no comments about whether the second defendants, who are defined as people who currently intend or who are likely to embark upon a course of protest amounting to the unlawful harassment, there's no comment at all about whether they've been served. There's simply a comment that the first defendant had been aware of the proceedings. And the only authority that's relied on for the jurisdiction is starts at paragraph 15. And again, it's a trespass case.
This is a trespass case.
I think it's a trespass case in part. It's a harassment case and a trespass case. But it's not clear from paragraph 15 whether the judge is simply adverting to the fact that there exists a power in trespass to make orders against persons unknown, or whether that was also one of the causes of action in play.
But yes.
Harassment is clearly in play. I'm not 100% sure whether trespass is as well.
Yes.
It may be that she simply refers to it as a parallel jurisdiction to make.
I think that must be it. Yes.
And then the normal citations that we see in these cases of Bloomsbury and Stone and Williams. But I think I'm right in saying that Stone and Williams is an interim case. And that is the extent of the reasoning in that one. But it was relied upon in Brett Wilson LLP and Persons Unknown, which is at tab 7 of the new bundle. Again, this is Mr. Justice Warby in 2015.
So which tab are you in?
Tab 7.
Mr. Justice Green.
Oh, I'm sorry, my lord, perhaps I've got the wrong tab. Try tab
6,
6. Tab 6, I'm sorry.
Right. Overruled this. Yes.
But this again is a different context because this is a defamation claim.
Right. This is the website.
And I wonder if this is the case that my lord the Master of the Rolls was thinking of. This is the Solicitors from Hell case, where there was a website where you knew there were authors of that website, but you couldn't identify
that
them.
is the case. That is it. Yes.
And so, in this case, there was a Norwich Pharma Court order to find out who operated the Solicitors from Hell website.
Right.
And that search generated 2 email addresses. And so service was effected to those addresses, but there was no reply. And so the action and the injunction were eventually issued against persons unknown. At paragraph 10, actually at paragraph 8, just looking back, again, the jurisdiction is exercised on the basis of Bloomsbury, Stone and Williams in paragraph 9, and again in 10, reference to Novartis. And at paragraph 12, we can see that the claimant emailed the email addresses with the claim form, particulars of claim, response pack, the interim order, and all the evidence. So that there was no question that service hadn't been effected against the defendants insofar as they could get a handle on them at all. So again, this case is different not merely by being in libel, but it's another different species of unknown defendant.
But these are people who clearly existed, who had run this website, and who it might be thought could be served by communicating with
Yes.
that website. Is that?
They are category 1 defendants.
Yes. And this is referred to without adverse comment by Lord Sumption in Canberra. He does refer to this.
He does,
as an example of the development of the person's unknown jurisdiction.
That's right, and can we turn that up briefly, my lord, because I had a look overnight at those
This
cases.
is a final injunction case.
It's a final injunction case following application for default judgment. So Cameron is in the original authorities bundle at tab 17. And this is the paragraph in tab 11, tab 11, paragraph 11, this is the paragraph in which Lord Sumption identifies the two main contexts in which the jurisdiction against persons unknown has been operated. The first context being the abuse of the internet, and the second, trespasses and other torts committed by protesters, demonstrators and paparazzi. Cases in the former context, so the internet abuse context, include Brett Wilson, but it's not disapproved, and Smith and unknown defendant, pseudonym Likicare, which I've put in the new bundle of authorities, I think at tab 7, which was again a defamation case, and again not disapproved, not disapproved of, and it was a final injunction. I confess I haven't gone on to check Middleton and Persons Unknown and PML, but I did go and look at cases in the second context. Hampshire Waste we'd already seen, INEOS we'd already seen, but UK Oil and Gas was again an interim injunction. So the two internet abuse cases, if I've got it right, are final, but the protest cases are all interim.
Say that again. That the internet cases are final.
Yes.
So that's Brett Wilson and Smith.
Brett Wilson and Smith are
They're
final,
Yeah.
But the protester cases,
referred to are all interim.
The three there, Hampshire Waste, INEOS and UK Oil.
That's right, my lord.
and Lord Sumption does refer to Brett Wilson again at 15 by identifying that alternative service had been affected
Yes, that's right.
in that case.
And also refers again to Smith
Yeah.
in that paragraph. But what I don't think we can tell from the analysis of those cases in Cameron is whether what Lord Sumption then says at paragraph 17 about a person cannot be made subject to the jurisdiction of the court without having such notice of the proceedings as will enable him to be heard. I don't think we can say definitively that it doesn't apply to final injunctions. He considers both types of case and expresses no view. So it's open to interpretation that it does apply to final injunctions as well as interim.
Well, it's not identified one way or the other.
No,
It's not something he addresses
No,
expressly.
expressly.
And of course, it was such a different case because the hit and run driver was obviously existed. It was simply a question of the name,
Yes.
the identity, who that person was.
I don't think in that case a Norwich Pharmacal had been made against DVLA or the Motor Insurers Bureau, but I'm not 100% sure of that.
Anyway, because they didn't know who if the car had been stolen.
Ah, thank you, my lord.
No, forgive me. No, sorry. That's right. The owner of the car refused to say.
To say who
Very
had been
odd.
driving it.
Yes, you're quite right.
It's the common speeding ticket problem.
Yes, right.
That's all I wanted to say about the recent cases on final queer timmets against persons unknown, apart from the Birmingham case, from last November, which
Can I just get back to that point about service? I mean, his conclusion on 26, you can understand that true it is that the driver of the Meister car cannot be identified. The main point was if you can't identify this particular person, you know they exist, there's simply no way that you're going to be able to, even by alternative service, notify them. And they may have been living in this country or not living in this country. They could be anybody. But I'm just trying to test you in a way on this, the point that I made before, which is admitting all the things about the width. I mean, the likelihood is that if you have protesters against a shop who are going to come down there, particularly those who are likely to commit unlawful acts, it is likely that they are, in this day and age, connected by some sort of social media.
Yes.
It's highly, highly likely. And that by social media, you could actually make it quite clear to anybody who is of the persuasion to protest against animal fur, animal skins, that you can notify them that there are these proceedings that are on foot and are being taken with a particular purpose. That seems to me in a different category from the hit-and-run driver who you just know nothing about.
I agree, my lord. Yes, I think they both fall under the broad heading of unidentifiable defendants, but the difference is that you have a much greater chance of communicating with the newcomer protesters.
At the end of the day, what Lord Sumption is saying is it's not in the nature of our court processes here to make orders, whether interim or final, let's not get into all that, to make orders against people who have no realistic prospect of knowing about the proceedings, and so that alternative service wouldn't help in drawing them. I mean, you shouldn't have an order for alternative service unless you're satisfied that there's a reasonable prospect that the alternative service will come to the notice of the person.
Indeed.
It's not just a kind of it's not just a fig leaf. But so that's why I'm not sure what there's other issues here about the width and everything else.
Yes.
But on this specific point, which after at the end of the day is what Cameron was about, it was about the ability to give notice to somebody against whom an order is sought to be made that the proceedings were on foot. And he's basically saying, well, that sort of person you can't serve, and that alternative service isn't going to help you.
Yes.
So what he would have thought about on that specific point, about this sort of case, one doesn't know.
I agree.
I mean, there may be lots of other objections to this, but I don't think in terms of notification it's in exactly the same category.
I think my lord is entirely right, and the question remains whether you can read that line in paragraph 17 as applying to this situation. It is a fundamental principle of justice that a person cannot be made subject to the jurisdiction of the court without having such notice of the proceedings as will enable him to be heard. If you can satisfy that by sufficient social media notice, then on the basis that the court has an inherent jurisdiction to make any sort of injunction it wants, and there are comments about that in Dame Elizabeth Butler-Sloss's judgment, but working on that assumption, if you can fashion the service and the notice to meet that requirement, then potentially I would accept that you could injunct third person, those newcomers who are unknown. But it is quite a high test.
So which is the high test?
The level of notice that you would have to give them.
Well, it has to be alternative service. In other words, I can't remember the exact definition.
Yes, such as reasonably
likely to draw it to the attention of the people affected. That's the only issue. Either it is or it isn't. But I'm just testing the case on this. As I said, we're talking here about people. We are talking about people who are identified in the persons unknown as people who are going to commit unlawful acts, not people standing with placards. But that's what we're looking at. We're looking at those people. Maybe that's what I'm suggesting. But I don't know. It's
Perhaps
an
this-
answer to all of this. I'm just trying to see where Cameron gets to, and it's not helped by the fact that Lord Sumption doesn't really deal with these cases directly. I mean, he points out the conceptual difficulty, which I understand.
Yes.
But that draws you, since the whole case seems to be about the question of are they properly served by alternative service
Yes.
or direct service, that's what we have to focus on here.
That's right, and it might be helpful at this point to look at how, at the Birmingham case, and look at how they resolved that particular issue. That's at tab 9 of the new bundle.
I mean, there's lots of other, I'm sure, come with lots of other issues about whether we should be using, trying to shoehorn the civil process into what is, at the end of the day, I might say a policing issue or a local government issue. That's a different point.
Yes.
So which tab are we at?
We're at tab 9 in the new bundle. So this, as I described before, is the case of...
Which number are you up to now? 1, 2, 3...
I have...
This is your fifth
This
point.
is my 5th point, in fact, my lord.
Have you gracefully slid over 4?
I thought 5 followed more naturally. I can come back to 4 if my lords would like further discussion on Venables.
It's just that certainly the Master of the Rolls and I like to follow the numbered headings. So we're on to 5 and you'll be coming back to 4,
If
which
required.
is fine, absolutely fine. So we've come to the Birmingham case.
Yes, my lord. So this is the protests against the nature of sex education teaching at a particular school in Birmingham. And if you, on the cover page, the 4th defendant is described as persons unknown seeking to express opinions about the teaching at Anderton Park Primary School. So a broad definition of persons. On the front cover, my lord.
It's tab 9 of the supplemental. The one there.
I'm sorry.
My fault. So sorry. Oh yes, thank you. So sorry. Yes.
So that definition doesn't refer to future unlawful conduct at all. It describes the persons unknown as doing a perfectly lawful activity. There were also 3 other named defendants. Paragraph 4, you can see the cause of action in the 4th line. The council's case was that the protests involved nuisance and disruption, though in fact later on in the judgment at paragraph 25 we can see that the actual source of the power to grant those injunctions was the Anti-Social Behaviour, Crime and Policing Act 2014. If I can ask my lords just to keep a finger on paragraph 4 and to flick ahead to 25. Section 1 of that Act provides the power, and it's a wide power. Antisocial behaviour is the target, and it's defined in section 2 of the Act as conduct that's caused or is likely to cause harassment, alarm or distress to any person. But as Mr. Justice Warby points out later in the judgment, harassment there is not the same as harassment as defined in the Protection from Harassment Act. Going back to paragraphs 4 and then to paragraph 5, there was an interim injunction made pending trial, and that one of the aspects of that injunction was the creation of an exclusion zone. And at paragraph 10, in fact, paragraph 9, if we start there, we have the judge's directions for the case to proceed to trial. And an application for joinder by a fifth defendant. In paragraph 10, permission to amend the defences of the first three defendants, expert evidence directions, and a refusal of the application by that fifth defendant to be a representative defendant. And I only draw attention to those two paragraphs is that's the only real description of the procedure that was followed, and there's nothing in it about the nature of the service that was effected. It wasn't at issue that the court, on the face of those provisions in the 2014 Act, had power to grant an injunction restraining behaviour as by an adult which qualifies as antisocial behaviour. There's then some discussion about the discrimination aspect of the claim.
What's interesting about this, we'll see what he decides at the end, but what's interesting is it's the same Act, I think, that provides for public spaces protection orders.
Is it, my lord?
I think it's the same. I think it's the same one that provides for that. But this was, in a sense, like the present case, an application intended to deal with civic disorder. And they did, in fact, apply, as I said, there wasn't an injunction for an exclusion zone here. Yeah.
There's then a lengthy discussion about the facts and the nature of harassment, but for our purposes, the relevant discussion starts at paragraph 129 under the heading of liability issues.
Can we just pause there? You're going to have, can I just deal with 121? I haven't looked at this case before. So he is satisfied. He's satisfied the defendants acting in concert. They committed public nuisance, obstructed the highway, repeat such conduct. So the council was entitled to appropriately forming injunctions on those grounds. So what is he doing? He's doing. There are some things he's granting injunctions for and some he's not. Is that the way it works?
So far as I can tell, he thinks that he has the power under Section 1 of the Act to grant antisocial behaviour restriction injunctions. He also thinks that the torts of public nuisance and obstruction of the highway are made out.
Yes.
And then it's not entirely clear to me under which jurisdiction, the common law jurisdiction or the statutory jurisdiction, he then decides to make the final injunction. Because as you say, my lord, having made that finding at 121, he then goes on to discuss the nature of the injunction sought. And at 129, the principle in question, in the very first sentence, the question that remains is how to address the claim against those unknown persons who may in future protest or threaten or intend to protest within the exclusion zone in ways that will be prohibited so far as the first three defendants are concerned. And that is exactly the question that we have in this case. These are the newcomers.
Yes, except that here it is building on the fact that there is prohibited conduct in relation to three named defendants.
Yes.
And he's then looking at the persons unknown injunction through the prism of that.
My lord, yes.
Hence, he says, in ways that will be prohibited as far as the first three defendants are concerned.
Absolutely, and of course in this case we have the problem that we had no one joined and so
Exactly.
no summary judgment was possible. But assuming that proper service had been effected against
Yeah.
defendants in the instant case, and Mr. Justice Nicklin had felt able then to consider the question of injunctions. This is what he was being asked to do. So Mr. Justice Warby then considers Cameron and Ineos and says these and other cases, this is at the bottom of the page in which paragraph 129 starts, these and other cases establish that it can be legitimate in principle to grant injunctions against persons whose identity cannot be ascertained at the time.
So I haven't got that.
I'm sorry, my lord, paragraph 129,
Right.
bottom of that page in 129,
Oh, I see.
these and other cases establish.
Yes.
But he doesn't specify there whether it's legitimate in principle to grant those injunctions at an interim or final stage, but he's discussing final injunctions, so we assume he means final. He then states that he considered the original formulation of persons unknown that he'd been presented with was too wide, and that he'd limited it at the interim stage to a class of persons against whom it was legitimate to grant.
So can I just say that I think the way he begins paragraph 130 suggests to me that he's conscious that, as he says, at this final stage of the litigation it's necessary to look at this issue afresh, which I think
Implies
that he
knows.
what he said above is dealing with interim.
I agree, my lord.
Yes.
And then he applies the checklist of requirements in Ineos, which he considers to be satisfied. And at 131, he then discusses the effect of Cameron and takes that sentence in paragraph 17 that we've been addressing, that orders can only properly be made against those who've been properly joined as parties to the litigation and given an opportunity to contest the claim. That's not an exact quotation of that line in paragraph 17, but it's quite close to it. He says, this is not a fundamental problem here. Mr. Allman is such a person, having received notice of the proceedings and joined as a party. There will no doubt be...
I have lost you.
Oh, sorry, paragraph 131, my lord.
1, 3. Oh yes, I'm there now.
Fourth line.
Yes.
Mr. Allman is such a person, having received notice of the proceedings and joined as a party. There will no doubt be others who still cannot be identified, but who have been served with the proceedings pursuant to the arrangements for service put in place in the interim period.
We don't know what that is.
So we don't know what that was, but we know some method of service was ordered. And those are the Category 1 defendants who were unidentifiable but turned up to the protest, and somehow they were served with the proceedings.
Yes, because that is quite, didn't happen in this case.
Didn't happen
That
in
is
this
quite
case.
common. Served not only with the order but with the claim form.
Well, it seems to be common in trespass cases and less common, and that's the whole nub of the issue in the protest cases. Do you mimic the trespass procedure
Yes.
and put the claim form with the interim injunction on
Yes.
stakes all around the vicinity, plus putting it on social media? And that would give you, one would have thought, the biggest coverage you could hope for, and you could then have your Category 1 defendants simultaneously having notice of the injunction and being joined to the proceedings under the Gamel principle, because they've got notice of the claim form as well. That solves your, I think, what the appellants call the procedural conundrum. And I think what they now accept would have worked in this case. So that appears to be what happened here.
And he stresses that they've had a fair, as a result of the service, they've had a fair and proper opportunity to participate, albeit they haven't taken it.
Indeed, my lord.
And he then goes on to say, so therefore he sees no reason why he shouldn't make a final order, which again seems to me to bear out my Lord Justice Richard's point, that he is conscious that he is here turning to deal with something as it were, at least potentially different, i.e. the making of a final order.
My Lord, yes, but he confines it in paragraph 132 to those category 1 defendants who have been served.
Yeah.
And what he declines to do is to extend that to the newcomers.
Yeah.
And we see that at the top of the final page of the report. But these points, whatever might be their merits at the interim stage, cannot, I think, be relied upon as a basis for final orders against a broad group of unidentified individuals of indeterminate number, let alone a body of fluctuating composition. And that's the critical element, isn't it? It's that the newcomers and those protesters will be a body of fluctuating composition, so that you can never really guarantee service, although you can achieve, as my Lord the Master of the Rolls points out, very broad coverage of service. And then he goes on to cite...
But just pausing there, again trying to be pragmatic, let's assume that you start your proceedings in the proper way against persons unknown, properly circumscribed. There's then provision for service on the category of persons unknown in all ways you've identified, which is something at the shop, handing out the interim injunction, the claim form, particulars of claim to everybody who's there at the time. You do all that stuff, and social media. And then let's assume you then get to the stage, as in this case, the injunction was limited in time.
Yes.
And you get to that stage, then would this be right if you followed Mr. Justice Warby's approach? It's true that you couldn't have the injunction against newcomers thereafter, but you could capture everybody who up to that date had participated.
And had been served. Yes, my Lord.
Well, but that's it, been said. You've got social media as well.
Yes.
So, I mean...
So it wouldn't just be participated, it would be served, I think, is the critical point.
I mean, obviously a counsel of perfection is to give them the stuff that people who are there. But
yes.
But, I mean, I'm just trying to find out how far we go on this. Do you accept or not accept that at least you'd capture all... I mean, because this could be a year or 2 years later.
Yes.
So you'd have thought by that time most people who wanted to protest would have protested. So at least you would have captured all that group if they'd been there before.
My Lord, yes. I accept that.
I mean, there's a problem about enforcement. There's a problem about enforcement because you've still got to identify who has been there before if you actually want to have them for contempt. But that's going to be whatever course you take.
Exactly.
But is that right?
I think that's right, my Lord,
You could do that. So in that sense, those are not newcomers. Those are category 1 people who you haven't been able to identify.
But who have been served.
But who have been served.
And that's the critical element.
Parties. And that might be good enough.
And that may have to do if you are to respect paragraph 17 of Cameron.
So here we don't know what the procedure was that was put in place.
We don't.
But because of the distinction he draws at 132, it doesn't look as if it's as general as some form of social media notification.
No, and I confess I can't recall seeing any mention of the use of social media. And of course this is
Also, it's a different
issue.
It's a very different sort of issue.
Yes, it's a school situation. It's super sensitive within the community.
But Mr. Ullman was there specifically because of social media. If you look at paragraph 9, he is joined, he asks to be joined because he said it raised freedom of expression arguments that restrict comments on social media.
My Lord, yes.
So,
I haven't noticed that.
It was in play.
So that is the most recent authority that synthesises Ineos and Cameron and applies and is on all fours with the order that the appellants wish to make against persons unknown in this situation, assuming that all the service requirements had been in order.
Very helpful indeed.
My Lord, with an eye on the time, I'm not sure that it's going to be of much assistance to you if I take you through Venables in its original incarnation and then discussion in the most recent Venables case. You have both of them in the bundle. I think my Lords have the principal points.
This is your heading 4.
This is my heading 4, my Lord.
the against everyone heading.
The against everyone. We're going to have to come up for something for queer Timet as well. We can't let that escape through.
Anticipatory and anticipatory injunction.
Doesn't capture the fear element, my lord, with respect.
Do your best.
I'll rummage through my A-level Latin translations. But so the two Venables cases are at the supplementary bundle, tab 1.
We'll look at those, Aaron.
Tab 1 and tab 8
Of the new bundle.
of the new bundle. And if you started in tab 8 with the most recent judgment, that gives a pretty comprehensive survey of Dame Elizabeth Butler Sloss's original judgment and everything that's happened subsequently.
And that's the president of the family division.
It is, my lord. The only other point that I wanted to clear up, and this is my point 6, was I think the only issue that we hadn't touched upon from the original list of issues, which was issue 5.10. My lords may not think it's of great moment anymore, but for the sake of completeness.
What was 5.10?
5.10 was about whether the substitute order provided by the appellants to Mr. Justice Nicklin was appropriate to meet his concerns.
This
But-
is the appropriate formulation
Yeah.
of the defendant.
And we've been through that order in some detail, and the only point that remains from it is the discussion in Hampshire Waste, Redwith, Aeneas and Quadrilla about the use of the terms intention and effect in descriptions of persons unknown. I've set my thoughts about those issues out.
Where do they arise in the text? Can we look at the actual... Well, the best place to pick it up is in this redrafted order, which helpfully has been supplied to us with colour coding.
Can I just be clear? In Ineos, was the concern about the description of defendant or about the terms of the injunction?
My lord, I'll have to check.
I may be wrong. I mean, in Hampshire Waste, it was the description of the defendant that was an issue. Maybe I just in Ineos that was the.
I think it might be both, my lord. Paragraph 33,
33.
This is paragraph 33 of...
Aeneas. Tab 18 in the original authoritative standard, my lord.
Yeah, tab 18, paragraph
33, I think.
3.
And that's the submission for the appellant made in the context of section 12.3 and whether the judge had properly considered it, that the injunction should not in any event have been granted against the fifth defendants in conspiracy because the term of the injunctions were neither framed to catch only those who were committing the tort nor clear and precise in their scope. I'm just wondering if there's anything more specific.
This is. See, I think that.
And
I mean, this is
Picked up at
dealt with in
39.
Quadrilla as well,
yes,
and where the point. I mean, what Lord Justice Leggett, the point he made there is that the problems about introducing references to intention in the description of the defendant is that it introduces a subjective element in what should really be a sort of objective description. But what Lord Justice Leggett says in paragraph 74 is that the same objection doesn't apply to a term of an injunction, although you may have to be careful. I just wasn't sure. I mean, certainly in Hampshire Waste, the problem related to the, I think, the description of defendant.
I think paragraph 39 of the NAOS is
Right.
helpful
And it's dealt with.
because that expands on 33.
39.
Yes, my lord. And Lord Justice Longmore thinks that the judge has attempted to do the impossible. This is in the middle of the paragraph. He has, for example, restrained the fifth defendants from combining together to commit the act or offence of obstructing free passage along a public highway or access to by, one, for all intents and purposes, slow walking in front of the vehicles with the object of slowing them down and with the intention of causing inconvenience and delay, or two, otherwise unreasonably and without lawful authority or excuse obstructing the highway with the intention of causing inconvenience and delay, all with the overarching intention of damaging the claimant. So that looks like it's the terms of the injunction, not the
Yes.
description.
Yes.
And then at 40, Lord Justice Longmore seems to criticise the idea that you can incorporate the idea of harm being caused by reference to intention.
I mean, I think the position is made reasonably clear by Lord Justice Leggett in Quadrilla, because he endorses Sir Andrew Morris's concerns about including intention in the description of the defendants, but says that the same concerns don't arise simply by including intention in the terms of the injunction. It's at paragraphs 73 and 74.
My Lord, that's right. I've addressed Lord Justice Leggett's comments in my supplementary note at paragraphs 23 and following. And I've set out at paragraph 32 the description of persons unknown in Hampshire Waste.
Yes. Now, assuming this is a concern that is really focused on the description of the defendants, is that a problem in this case?
The only way in which it arises in this case is, I think, if we turn to the
There's no
new
reference to
order,
intention in the revised description.
I think there is in the definition of demonstrators, or there was in the original Act. It might have come out now, because in the original Act,
Well, I'm looking at the revised version.
so it's out now, I can see. In the definitions section on the bottom of the second page, in this order, little Roman 3, in this order, demonstrating and demonstrate means carrying out an activity including handing out leaflets as part of or in furtherance of their campaign.
Yeah, but hold on, aren't we looking at the description of defendants, i.e. on the front page of the order? Isn't that what this is concerned with?
Yes, but I think what's being said is that in itself it doesn't contain reference to intention, but it does by reference to the definition of protester or protesters.
That's right, my lord.
So that's in
That's rather, because
mind you, it does say in this order, so I'm not sure it covers the heading, to be honest.
yes.
It says view the first defence and it says and protesters as defined in this order, disobey this order. And protesters are people who demonstrate or intend to demonstrate. Well, the intend to demonstrate, I think,
That's it.
the intent to demonstrate are the newcomers, aren't they?
That's right, it's at definition 10. This order, protester or protesters shall mean any person who demonstrates or intends to demonstrate, and that was in the original order as well.
But
My
this
lord.
is very
Just been-
odd. I mean, because the first defendant is defined in terms which do not include any reference to intention or any state of mind. This is in the cover. And then it says at the end of that brackets, protesters, close brackets. You then get to paragraph 1 of the order, the injunction, and it says the defendants, and then in green, and protesters, as if they were somehow different from the defendants. And that, as you rightly said, then brings in the definition of protesters. The fact is, this is, with all due respect, a nonsense. Because the injunction is against the defendants, who are persons unnamed.
Yeah, so the word protesters there is redundant.
Yes, but
And it's importing
it's importing
a new element, a new definitional element.
Yes, something's gone quite badly. I now take your point, because if one looks at the description of defendants, there doesn't seem to be a problem there. But when you then see the persons to
Yes.
whom the injunction is addressed, then there is that problem.
And I noticed that point after I'd written my supplementary note. So in fact, I said that there wasn't a question about intention at all in this case, at paragraph 27 of my supplementary
Yes.
note, but that's not right. It arises in the way you've just described.
But if you take, as I understand it, on the formulation of this case, it is
They really ought to just delete them,
The word
define totally.
but it's the word "and protesters." I think
Yeah,
we probably
take that out.
who intend to cover the newcomers, aren't they?
Well,
But they don't need
But they
that.
don't need to, because the newcomers will turn into the first defendants as defined when they arrive at the location. They don't need to be caught in advance.
Well, I'm just trying to work this out. Sorry, I'm afraid lost the track of this. Is this draft order, Mr. Bezier, is this for the interim injunction or the final injunction?
My lord, this was the injunction put forward for the final
For
injunction.
the final
It
injunction.
was, yes.
Right. Okay. But anyway, well, we'll have to see what you said on that. But
So, if that were to stay in, then the objections of Sir Andrew Morritt and Hampshire Waste would apply. Lord Justice Legate's caveat, as he puts it, to the Aeneas requirement and discussion of Hampshire Waste and intention really only goes to the terms of what's being prohibited, not to the definition of the injunction, where the objection, I think, still remains. And it is possible, following Lord Justice Legate's description, I think, to use both intention and the language of effect in the terms of an injunction to describe the harm, because the critical nexus is the harm that's going to be done, and there are various ways of doing that. You can say it's the object or the purpose. And that, in some cases, may also get you over the difficulty between tortious and non-tortious acts descriptions.
I need to sort this out. So you're saying that there remains an objection in defining your defendant group to refer to intention.
My lord, yes.
And the reason for that is it's imprecise.
It's imprecise.
Right, okay, let me just make a note of that.
And it gives rise to the difficulties that Sir Andrew Morritt discusses in
Exactly.
Hampshire Waste, which are not, as it were, overridden by Quad River.
Indeed, my
yeah,
lord.
they're endorsed by.
I was going to say,
And those difficulties are detecting intention on the ground and proving it subsequently.
So just pausing there. So if you remove the word protester, and so you just have the defendant, let me just see where that would what effect that would have.
well, protesters is used throughout, isn't it?
Well,
And all protesters.
I know, but I mean, you wouldn't. So
You would just substitute protesters throughout for put first defendants in instead.
you delete protesters.
You delete protesters.
Yeah.
But I think then we'd have to ask Mr. Bates in due course, because he wants to include this category of future people. It's a final order.
But they would still be caught by persons who are present at and in the vicinity of, because it's not going to apply to Mrs. Smith sitting at home wondering whether to protest, but as soon as she turns up to the location and starts protesting, she's caught. The fact that you give notice to her before she gets there doesn't affect this definition at all. That's just a procedural safeguard for her.
You say, as currently worded, it falls foul of the requirements.
In Hampshire
And you
Waste.
say, as far as you can see, it doesn't do any harm to what's intended by just deleting protesters and referring to defendant.
My lord, yes.
That's what it will seem. Right, now, that's fine. Any more?
My lord's
really
no.
helpful. Can I just ask you this? I mean, depending on what we decide about grounds 1 and 2,
Yes.
and the consequence of deciding one way or the other on ground 1 or 2, we could simply, let's assume hypothetically for the moment, because we haven't made up our minds, that we were to decide there hadn't been good service here, and that PETA, there's no point in maintaining PETA because there's no real claim made against PETA.
Yes,
That would be the end of the matter, and we could simply leave matters there.
you could.
On the other hand, it would be, I sort of thought, helpful to the parties here to say something more. But on the other hand, we have had the very considerable assistance that you've given, but you're not a party.
I'm not, my lord.
And it may be that a party who's a defendant might want to say something rather more. Is there anything you would want to say about whether you would think it would be a good idea or not a good idea for us to express any views about, in terms of general principle rather than this particular case, about interim injunctions and final injunctions in a case of this kind?
I think it would be extremely helpful for you to do so, my lord, but it's going to require a judgment of considerable synthesis to bring all of those strands together. But there is no Court of Appeal case that addresses this squarely. There are a raft now of conflicting first instance decisions, and so guidance would be useful. You're also in a position to take into account, but though you're bound by it by Cameron, and to interpret paragraph 17 as Cameron. And it may be having done that the case goes further.
Well, I mean,
But-
I don't know about that because it would all be strictly if in that hypothetical
Well-
situation, which I say we haven't yet determined, it would all be obiter.
Quite a lot of the points are I think are squarely could be the ratio of this. You've got to decide whether you can make a final injunction against persons unknown.
And if we say we're against them on the first 2 points, that's the end of the appeal. The case fails.
But in
No
doing
service
that,
and PETA goes.
But in doing that, you can discuss the service requirements and what is the best procedure to be followed for service in persons unknown cases. I'm not quite sure whether that would sit strictly in ratio or have a toe in ratio and a toe in
Anyway,
obiter.
that doesn't matter. The main point is you think it would be useful for us to say something.
My lord, yes.
Well, that's be better. Yes.
Lord, may I deal first with the form of the order? I understand from Mr. Buckpitt that the reasoning for including protesters in the order was to make clear in easier language for those getting the order who it was intended to be for. And so one notes that from page 193 under Roman 12. That was the
193
intention.
of what?
That there were protesters.
So 193 of what?
193 of the core bundle, my lord.
Oh, but I was using.
Yes, it's the third page of the draft.
Yes, that's the definition of protester.
But the difficulty is that isn't the same definition as appears in the description.
My lord, that's right. I mean, I think the point is that the reference to protesters is unnecessary because the defendant.
On the third page.
Yes.
Yes.
And clearly, there's no need, and it would be unnecessary to have any reference to intention whatsoever.
Right.
Well, that was the rationale for it, I understand.
Right.
Well, can I deal first with the two issues of principle, namely, can final anticipatory relief be granted against persons with our reformulation? And secondly, if it can, to whom would such an order apply? Namely, would it apply to newcomers, and howsoever they are defined? And can I consider first the petition of interim relief and its potential consequences for a person, and Lord Sumption's judgment in camera. Well, Ineos and Quadrilla are authority that It-
Something. No, I didn't quite catch you. You said you talking about interim relief.
well, Lord, yes, I'm going to consider first the position of those facing interim relief and the consequences for them, and then go to Lord Sumption's judgment in Cameron. Lord, Ineos and Quadrilla are authority that interim anticipatory relief may be granted against persons who are identified only by reference to future acts they may commit. And this is now an established class of defendant, namely persons who are not yet in existence and may never be. So it is a somewhat novel class of defendant looking towards the future. And it's right, and we accept, that service of an interim injunction on a person who is doing nothing wrong does not make them a party to the proceedings, given the definition of defendants, and nor does service of the claim form on them at the same time. So in a sense, the innocent protester at Canada Goose, if they were served with the claim form and the terms of the interim injunction, would receive them for information purposes only. But following service and upon commission of the acts complained of, then by virtue of gamble they automatically become a party and are bound by the terms of the injunction. And if that injunction has been made without notice, then clearly they have become subject to the jurisdiction of the court without having had any notice in advance of the application or the ability to be heard. Well, can I now go to Lord Sumption in Cameron, please, at tab 17. And paragraph 10 of his judgment, he refers just between D and E the possibility of a much wider jurisdiction being first opened by Vice Chancellor in Bloomsbury Publishing.
So paragraph 10.
My Lord, yes. And then at paragraph 11,
So which bit of paragraph 10?
my Lord, it's between D and E,
Yes.
where he just relates the possibility of a much wider jurisdiction was first opened up. And he discusses Bloomsbury,
Yes.
and then in paragraph 11 refers to that jurisdiction has regularly been invoked, and sets out the two categories of case.
Yes.
And he notes on paragraph 11, he refers to both Ineos and UK Oil and Gas, and notes that in some of those cases, proceedings against persons unknown were allowed in support of an application for a queer timid injunction, where the defendants could be identified only as those persons who might in future commit the relevant acts. And he says there that the Court of Appeal in Cameron followed that body of case law in arriving at its conclusion.
Yes.
Now, later in his judgment, he holds that the Court of Appeal was wrong in this case, but he doesn't return to any of the case law referred to in paragraph 11 or express any doubt in relation to it. So we submit that this is implicit approval of the cases here, and in particular the technique of identifying a defendant by reference to future acts. In paragraph 14, on page 1480 of the report, between B and C,
Sorry, just give me that page.
1480,
Yes,
between B and C, my lord,
thank you.
there is the sentence, the court may grant interim relief before the proceedings have been served or even issued, but that is an emergency jurisdiction which is both provisional and strictly conditional. And clearly, what he is referring to as the emergency jurisdiction is the obtaining of injunctive relief without notice. and therefore, and then it's a provision of conditional because then one deals with service and the like, and then if one can name parties, ultimately one does. But he's not going any further when he's talking about an emergency jurisdiction. It's purely where one applies without notice, either before or having issued the claim. In paragraph 15, towards the end of that, he has referred to the case of...
So, sorry, justice absorb that. That's important. So, the point you're emphasising, I think, there is the words "or even issued."
Yes,
Because you're saying he's looking at a pre-issue injunction.
yes,
That's what he's looking at here. And what you're going to go on and talk about is, right, you're going to distinguish a situation where the proceedings have in fact been issued.
that's right.
And then the question is, have they been properly served?
That's right.
That's
all,
what we're going to do.
all he's talking about here is without notice relief, either before or after issue of the claim form, but before service.
Well, that may be reading a bit much into it, because you can still give notice of an application to the court for an injunction. You could do that before you've effected service.
Yes, we can give him formal notice, yeah.
You might actually give formal notice, but
But in terms of talking about the
anyway, I'm not
emergency,
quite sure. Yeah, he's talking about, yes, emergency jurisdiction.
yeah,
Yes.
I mean, I think that, so let's just see, slightly further up the page, he's saying the legitimacy of issuing or amending a claim form so as to sue an unnamed defendant can properly be tested by asking whether it is conceptually, not just practically, possible to serve it.
yes.
So that's the issue he's looking at. He's testing it. And then he goes on the court action personam. The actions completely constitute on the issue of the claim form, and the general rule is that service division is the act by which the defendant. And he then starts off by saying, well, you can. Well, your point is, he then, his first step in the analysis to say, well, you can have interim relief even before you've served the proceedings or issued them.
So it's the court not acting in
So
persona.
that's his first stage in his analysis.
That's right.
But he's saying, well, in that case, it's very, very strictly limited and provisional.
Yes, I accept that.
So I'm just trying to understand your reasoning. So you're saying, well, that's the first stage in this analysis,
That's correct.
but it's not looking at the situation where there has been issue. Once a proceeding has been issued,
And served.
and served.
It ceases to be an emergency jurisdiction.
Yes, that's the point you're making.
That's right. Now, I accept it remains a narrow one, because if one is dealing with persons who are not named, if there comes a time when you can name them, you should do so. And the court will be very slow to grant relief against persons who aren't named for obvious reasons. But it's not an emergency jurisdiction.
And then he goes, it's at that point he then goes on and talks about, well, okay, now what's service?
Yes,
So how crucial is service?
that's right. And then,
But why does it not apply in this sort of case? Why does he, because he's talking about interim relief before the proceedings have been served.
yes,
Necessarily in these cases the proceedings haven't been served. So is he not saying, well, this falls within what he talks about the emergency jurisdiction?
well, that's right. I think we accept in this case
That
that there should have been, there should have, yes, we accept
You
that.
say the interim injunctions in this case fall within that category.
Yes, they would.
Yes, that's
Or, well, save for the fact that, of course, we sought an order for alternative service having obtained the injunction, but that was having obtained it.
So the interim injunctions fall within within that sentence
Yes.
because there was not an order for, well, you didn't comply with any order for alternative service in this case.
But I think that the first point is that we sought the order without having any form of service in advance, and we were granted it. And having been granted it, we then didn't serve it we didn't get alternative service if you're against us on ground one.
The problem occurred in this case because you never served the proceedings because you didn't get an order for alternative service of the statement of claim.
My lord, that's right.
That's the reason you fall within. There's no other reason. That's the reason.
That's the reason.
If you'd got your order for alternative service to do what you wanted to do, as you say, which is to serve it by email
Yes.
in the way indicated, then it would no longer have been an emergency jurisdiction. That's the point I think you're making.
Yes.
It's not an emergency jurisdiction just because of the nature of the relief you're seeking.
No.
It's because you didn't get you didn't serve in accordance with an alternative process. But there wouldn't have been a difficulty, you say, in getting such an order,
My lord,
because
no.
your whole case is that's what was intended. It was a slip.
Yes. Yes.
Right.
Lord, in paragraph 15, Lord Sumption then refers to Gamble and notes there just by C that the Court of Appeal held that where proceedings were brought against unnamed persons and entry was granted to restrain specific acts, a person became both a defendant and a person to whom the injunction was addressed by doing one of those acts. In the case of anonymous but identifiable defendants, these proceedings for service are now well established and there's no reason to doubt their juridical basis.
So I haven't got that. I'm sorry.
Lord, it's the end of paragraph 15 on page 1481 at letter C.
Yes.
So he is endorsing the Gamble approach, and Gamble was a case where Mrs. Gamble only became a defendant upon having been subject to alternative service and committing the act of bringing her caravan onto the land. So it's our form of our definition of defendant.
Sorry, is it? Because what is Gamble not? Is, what Lord Sumption is referring to is interim relief.
Yes, yes.
So where interim relief has been granted, and someone then does the prohibited act with notice of the order and the proceedings,
My lord, yes.
as Mrs. Gamble did, she then has, that is service of the
My
proceedings.
lord, that's right, yes. And I accept it's interim only, of course.
But it's service of the interim order,
And the claim form.
which brings the proceedings to, and the claim form, brings the proceedings to the attention of that person.
That's right. And it's the claim form that is essential there to make her a party to
That's what Lord Sumption's referring to in the next paragraph,
Yes.
I think, where letter E, he's then saying, how can you serve? He says, nor is there any specific interim relief, such as an injunction, which can be enforced in a way that will bring the proceedings to his attention. That's tying in, I think, with what he said in paragraph 15. So anyone that has attended at the Canada Goose stall, if they had either been handed the claim form and the order and particulars claim, or had seen them on the window, they would have been served, is what the Court of Appeal held in Gamble,
Yes, yes, that's right.
and thereby became parties.
Only, well, not in this case, they wouldn't have become parties because they would only become parties had they committed the acts.
No,
Which
no,
were prohibited by the
well, that's the Gamble point.
That's the
They
Gamble
become
point,
parties by seeing all that,
That's right.
the documents,
Absolutely.
and committing the act.
Well,
And
that's because at that point they fall within the definition of defendant.
That's right.
Because the defendant defines them by doing the act.
That's right.
So they have to do the act before they actually
Yes.
fall within the categorisation.
And they're given notice of the proceedings.
And they're
at
given,
the
and
same
they're
time.
treated as having been given and served.
Yeah,
That's right. I think it's so.
Absolutely.
Yes.
yes.
So the 12th person in the exclusion zone wouldn't be caught by the definition.
Take my lord to go to the substitute draft order.
You can have up to 12 in accordance with the order. So the 12th person wouldn't be within the definition of defendants. So therefore wouldn't matter what they read or saw at the stall, they wouldn't be caught.
They wouldn't be caught until
they did something
Until they
that
were the
the order
13th.
prohibits, which
That's
would
right.
then be being the 13th
That's
person.
correct. That's correct. And equally, anyone protesting at the store who stands on Little Argyle Street and protests the entire day, it's perfectly permissible. There's nothing prohibited by that. They don't become a defendant. Absolutely.
And can I want to just, for clarification's sake, take up the point made my lord just to clarify. That we've been talking about people who have notice, but am I right in thinking that if there's a provision for alternative service, it doesn't actually matter, or does it, that they actually know that in fact they have seen it, because that provision deems them to have been served? Is that right?
That's right. It depends on the form.
Because I mean, they may not have looked at if there's a whole crowd of people outside demonstrating, they might not have seen what's plastered up on the window. But if that had been deemed to be alternative, if that had been ordered to be alternative service, would that still have been sufficient?
Well, if that was the order, but I don't think we would suggest that. I think we will be saying here that there needs to be personal service of the injunction on individuals.
No, but I'm not. I'm just talking about in principle.
Yeah, in principle.
In
Yes.
principle, the alternative if the alternative service says this is the alternative service,
Yes.
whether it actually gets their notice or not, in reality, doesn't matter.
I think that yes, that's right. That's right.
I
And so in Mrs. Gammel's case, the requirement was to place the writ on a post by the caravan. But there's no evidence that she actually came to her attention, but it was good service.
It's likely that she didn't see it, it was posted on her caravan.
Well, she then came there, and she was also literate, and
She bought it, yes, they addressed that.
that's right. And then it was. I think it was only when the injunction was read to her, she couldn't understand it. It was conceded. But anyway,
I mean, it doesn't, if you don't know an order that's been made, you certainly can't be committed for contempt.
I agree. I agree with that.
So
She's right.
it becomes difficult to say you've been served when you haven't seen it.
Just was curious in Estellas
So
that
that's the problem.
yes, in Estellas, I think it was sought to make individuals liable whether they knew of the order or not. In Estellas,
Yes, I see.
yeah.
No, I think that may, and it must be authority on this point, but I suspect it goes to the question of whether or not there's contempt.
Yes.
It probably goes to that point rather than whether or not they've been served.
Yes.
Because that must make sense. And if you provide for alternative service, then the proceedings have been commenced,
That's correct.
whether you know about it or not. And when you do the actual party, what the consequence of that may indeed depend upon whether you know about it.
Exactly.
But in deciding whether to order alternative service by posting the documents on the window of the store, the court would have to take account of the fact that if there's a crush of people, many of them may not see the documents.
Yes.
Therefore, wouldn't necessarily be an
Yes,
appropriate alternative service.
Yeah, it would have to determine what is appropriate given the nature of the protest and the various routes one could take, and that is social media, at the store, handing out, everything.
Yeah, okay.
Well, then one comes to paragraph 17 and the sentence that we've been looking at. It's a fundamental principle of justice. The person can be made subject to the jurisdiction of the court with having such notice of proceedings as will enable them to be heard. Now, clearly that needs to be read subject to the emergency jurisdiction referred to in paragraph 14. That is when one seeks interim relief without having given notice of the proceedings. But of course I accept that generally the principle is necessarily an applicable one which binds us all. But Lord Sumption is not addressing any other exceptions there may be to that fundamental principle, because that wasn't the purpose of the appeal in that case. Which brings me to that's what I want from Cameron Hussain. And then
So what are you saying? You accept that that's a general principle?
it is, but
So you accept that general principle?
I think I have to. But there's clearly an exception already identified in paragraph 14, and Lord Sumption is not saying that is the only exception. So the question will be...
14, that's a practical exception, which obviously has a very short temporal life, because you grant you're woken in the middle of the night to grant an emergency injunction before proceedings have been issued. You grant that injunction and you have a return day the following day or the Monday morning or whenever it is, and then effectively everything is regularised.
Or in this case, one grants it and the return day is 14 days thereafter. It's not ordinarily, not always, the next day.
No, but it's still a short period.
It is.
That's the whole point of it being an emergency
Of course it is.
position, and thereafter it is regularised, and what he says in paragraph 17 comes into play, because as he goes on to develop, it's effectively a principle of natural justice.
Well, that's right. So the issue which I need to address in this case is whether one can maintain that principle of natural justice by seeking to make orders that bind newcomers. But before coming to that, just in terms of whether a final anticipatory injunction may be granted against the category of defendant that we have, we submit that in principle there's no reason why not. Clearly, if one commences a claim against this category, and during the course of the proceedings you can then identify by name individuals who have either infringed or are likely to infringe your rights, then you should make them defendants. Accept that. But if there remain persons who it is impossible to name, the impossibility of naming them cannot, in our submission, be a bar to continuation of final relief.
Can we identify the categories? Because as Ms Wilkinson has helpfully said, there are people who you can't tell until they've actually fallen within the definition of defendant.
Yes.
They've done the act. You can't tell who they're going to be. These are the newcomer points. That's what you call newcomers. But once they've done the act, they are actually category 1 people. So they are people who you may not know, be able to say who they are, but you can say, in broad terms, you can identify them as part of a category of people.
And in fact, they are defendants.
And they are in fact defendants.
That's right.
So who are you talking about?
Well, I think there are two things. The first point is, I would accept that in order for someone to be bound on this first part of my argument, there would need to have been service of the claim form, whether by personal service or a means of alternative service, however that is so done. And of course, purely having effected service, that doesn't make them a defendant. No. It depends upon their conduct. But assuming that they do not breach the terms of the order and therefore do not become a party, nonetheless they have been properly served with the claim form. They know of the terms of the injunction, and they could, if they so chose, apply to be a party and say to the court whatever they wanted to say. And so for that category of person, we submit that there is clearly jurisdiction to make a final anticipatory injunction if all the other elements are made out. And that appears to follow from what Mr. Justice Warby held in the Birmingham case, save that the one caution with the Birmingham case is that the definition of unknown person there didn't depend upon their acting in breach of the terms of the injunction. It was simply those who are speaking about these issues. And so in the Birmingham case, the unknown persons who Mr. Justice Warby made the final order against were in fact defendants, because they had been served with the claim form. They met the definition of defendant, and they didn't require to do acts to make them a defendant. So it's slightly different.
When you say they've been served?
Well, we're assuming that that they have been served with the claim form.
Persons unknown.
Yes. I guess there's the category that there are some persons who had been served.
In Mr Justice Warby's case, they had not been served, and therefore he refused to make the order against them.
No, but let's turn it up.
I got this one.
He found that there had been service on some
Yes.
within the group,
Yeah.
and those people he found could be the subject of a final order,
My lord, that's right.
but only those. So he
That's right.
refuses to make the wider order that was sought, but does make, it can't be relied on as a basis for final orders against a broad group of unidentified individuals of indeterminate
My
number.
lord, that's right.
But he does say that it can be made, can only be made against persons who are parties to the action at this point in time.
My lord, and the point I'm making badly is that the definition of persons unknown was persons unknown seeking to express opinions about the teaching at Andon Park Primary School.
Yeah.
So they therefore, as soon as they were served with the claim form, they became a party to the action,
Yes.
and therefore, as Justice Warby was content that injunction relief could be made against them.
Yes.
That's our description.
Yes. Yes, that's in paragraph 131.
Yes.
etc.
I'm just not sure of the point you're seeing there. You say you could have the service of the claim form by way of an actual alternative service, and whether or not the person has in fact done anything, they could apply to be joined, and they could apply to be joined to the party, and they could say what they want. Well, where does this get us to?
Well, the point is that they are therefore persons against whom a final order can be made. Now, they haven't become parties because they haven't undertaken any of the acts prohibited, but they have got the claim form, they have got the injunction. The order will have said you can apply to be joined if you so wish, and they've chosen not to do so. And so when the court is seeking to make injunctive relief, they would be within the class of person that would be caught.
Because as he finds, they're parties to the action.
That's right, yes. Now,
But that may be because yes, but they fall. But I think he's talking about people who fall within the definition, because in that case you said they didn't have to do anything.
That's
They
right.
simply had to be people who had particular feelings about something.
Yes.
So all those people would have satisfied the definition.
Yes.
But you're talking about something quite different, which is people who haven't satisfied the definition. Well, how can they be parties?
No, well, I'm not saying that they are parties, but that but the court has jurisdiction to make an order against them because they have. We have done all that we possibly can to bring the proceedings to their attention. We served the claim form. They have the order. So they could, and they are potentially affected
But I thought that the effect of that very helpful passage, and Ms Wilkinson drew our attention to on the super injunction report, made this distinction between interim injunction and final injunction, that final injunction only binds parties. Now the problem you've got, I'm not sure where this is getting us to, but the problem in theory you've got is if it's a final injunction, they haven't yet done anything, they're not yet defendants, so they're not parties.
Well, I think, therefore, what I argue, and I should have said this to start with, is that the difficulty here is that the manner in which the defendants are described is by reference to future acts.
Right.
And so,
Well, that's right, to acts, yes.
to acts. And so, necessarily, unless there have been individuals who've been served as such and have committed those acts, there are no parties.
Well, that's the problem.
That's the problem.
That's what we're looking at.
Yes, absolutely. So the question is there power to grant final relief against that class of person? And we would submit there is. We recognise that this does give rise to the substantial issue of fairness.
I'm sorry to question this point. If a final order can only, say in this a limited case of protected categories, if a final order can only bind parties to the proceedings at the moment the proceedings are finalised, how can you have an order against people who were not parties at that point? I mean, that's the point I'm putting to you. I don't see how you can square that circle.
Well, but that's the inherent difficulty of this form of wording.
But you have, I know, exactly. But that's what we're here
Yes.
debating. That's the problem with the newcomer group. The newcomer group, as the people who are still potential newcomers at the date of the conclusion of the proceedings. That's the issue.
Yes.
What do you do with? That's what we're now debating. That whole issue is about. And what you've got against you is you've got, for what it's worth, the authorities and such statements as there are indicating that in a case of a final order, it's only the parties who are bound by it. And the effect of what you've just said to us, the proposition, is to circumvent that. Because you're saying, actually, you can make an order which is binding on people who are not parties to the proceedings, but in theory could become retrospectively parties. That's the issue.
Yes.
So are you saying that those that statement and the authorities referred to in the super injunction report are wrong?
I can't, my lord, no.
But then I'm sorry to press you, but how
No,
do
my
you
lord, yes,
respond?
I appreciate that. Well, I think we have to say that in effect, the order the court would make would almost take effect as a without notice injunction against those individuals, in the sense that the order would enable anyone in receipt of it. Well, firstly, it would provide the claim form is to be served. It would inform them of their right to apply to set aside or vary under 40.9. It would have limitations on the length of the order with built-in reviews, because it would be an order made not in a vacuum, but in a case where the court has been satisfied in relation to other individuals that there have been or are threatened torts, that relief should be granted against them, and that it's akin to an emergency jurisdiction. And it's actually operating no differently to where the court does make injunctive relief on a without notice application at the first instance. It then serves, and then all the procedural requirements are there and the protections. But this is actually no different, save that there has been a final order made, but you're still building up all of those protections, seeking to deal with what is a novel category of defendant, namely future wrongful acts. Well, I don't think I can put it any differently to that.
No, I mean, where I think we got to, I understand that's where you want to get to, but where I think we got to, at least with Miss Wilkinson, and she may be right or may be wrong about this, was she did recognise, she was prepared to acknowledge, that you could have a final order that bound everybody who had been participating over whatever period of time it was in the unlawful acts. You could do that.
Yes, and that would require service on them.
Well, you could have alternatives.
Absolutely,
You could have
yes,
alternatives.
yes, absolutely,
So
yes.
you have alternative
Yeah.
service right at the outset.
Yes.
You have alternative. I mean, the question is whether the court would grant such extensive alternative
Yes.
service, but assuming that it would grant alternative service for this category of people,
Oh, yes.
then you've got the period of the interim injunction, which I don't know how long was this one for?
For about 14 months.
For 14 months, so just over a year, and all of those people would be caught by the final injunction, even though you couldn't name them.
If they have undertaken acts, not
If they've
that's
undertaken
right.
any acts in relation to that, and you'd have to have some video and all the rest of it. But I mean, enforcing it is one thing; that's
Yeah,
a different
of
matter. But you would have that,
Yes.
and I mean that at the moment it strikes me as quite a value. If it were popular, if we felt at the end of the day we could say that was something feasible. I'm not saying we could.
No.
If we could, that is quite a significant advance, I
Yes.
think, on where we are at the moment. And that, I'd have thought within 14 months, you probably have had most of the people who are going to protest.
But the difficulty is that you have people protesting, but the majority complying because there's the order in force. And so if they're complying with the terms of the order, they wouldn't become parties, and therefore they wouldn't be bound on this analysis by the terms of the final order.
And I'm just trying to be kind of, one has to deal with the art of the possible.
Yes.
But what I'm saying is, if that's the most you're going to get,
Yes.
it's not actually without value, because within that 14 months, the people who are going to be the malefactors will have been there, and you'll already be able to identify 23 people. I don't know whether those are the serious malefactors or not. And it would also have the effect, I thought, on what you're very concerned about, which is having 200 or 300 people there.
Well, I mean, I've already remembered.
Anyway, there we are. I mean, I know that's not enough for you.
No, it's, yeah.
I mean, I try to understand that, but
And the difficulty that we have is that if the extent of the relief that we can get is, as my Lord says, in terms of individual named persons or people that we can identify who have breached the order in the last 14 months, then it does mean that there is nothing preventing anyone from congregating in very large numbers the day following this injunction falling, and we would then have to start again on an interim basis to seek to stop that.
But when you say there's nothing that can be done, I mean, there is police action, there are other powers.
Well, my lord, there is, but I mean, there are 3 occasions here where more than 100 officers have attended,
Yes,
and the store's been locked down for 3 or 4 hours.
yes.
That is, if that is where we're at in terms of what protection we get, well, so be it. But with respect, it's not satisfactory, and nor is it satisfactory that my client should have to rely upon Westminster City Council to exercise one or other of its statutory powers.
Well, you say that, but actually, I mean, having delved into some of the background material, I can't help feeling that actually it is primarily a local authority matter. I mean, looking at the material, I was quite struck by the effect of these protests on others, not your client's business, but the business of the shops 2 doors down, and the signs that say that you're ruining my business. I only have one job, and it does seem to me that that's the sort of thing that a local authority, taking into account all of the retail premises in this particular location, would be able to agree. And I share my Lord's concerns about trying to shoehorn what assistance we can give into this particular factual situation.
My Lord, certainly it is open to local authorities to exercise their powers. They have a wide range of powers. It's quite one thing for them to have the powers, quite another for them to exercise them, and yet another for that, for a private concern or concerns to seek to get the authority to exercise those powers.
I understand that.
But let's go back to the nub of your case. So where I think you ended up, correct me if I'm wrong, is that you say that there's nothing in Cameron which preclude, or anything else outside Cameron, which precludes the court from making a final order against people who have not yet become defendants because they've not yet committed the act which defines the defendant, but they have been served.
Yes.
That's your proposition.
Yes.
And you say that furthermore, I think it's an additional point, furthermore, even if you are wrong on that, the court should regard this exceptionally as a situation equivalent to Lord Assumption's emergency jurisdiction, where you could get an interim injunction, but you are dealing with a case where there may be future people may come along, and they haven't yet done it, but it's that sort of emergency jurisdiction which is here being invoked as regards that category. Have I got
Well,
those
that's
2
right.
points?
Yes.
Is there anything else you want to say about that issue of the final injunction and distinguishing or explaining Lord Sumption's statement in Cameron?
My Lord, no.
It's those two. It's really
Yes,
those
it
2
is.
points of what
It
it comes
is.
down to.
Lord, I only have a couple more points. I see the time.
Oh, right, yes. Sorry, what is it? So 2:05.
My lord, I hate to say this, I'm in some difficulty after lunch. Would it be possible for the court
It's 1 day and a half case, wasn't it, actually?
to sit for just 10 minutes more, Mr. Defendant?
Yes, absolutely.
10 minutes more.
Okay,
You do it now. Yes, oh, very well. Let's do
I'm
that.
very grateful, my lord.
I'm so sorry, I completely lost track of the time.
My Lord, just a couple more words. The case of Vastint, which I don't think the court's been taken to. Vastint.
Oh, yes,
That's the case. That's the judgment of Justice Marcus Smith.
yeah.
And that was the case that was a final anticipatory injunction to restrain threatened trespass. I think my learned friend said that Vastint was a case where there were named defendants. There were no named defendants. It was purely unnamed defendants. There were 5. This is just my Lord's note. It's tab 16 of the authorities bundle, and there was no one trespassing on any of the sites. It was purely based upon threats of trespass from persons unknown. Firstly, from those bringing caravans on, and those using the land for raves. And the judge did grant final anticipatory relief against, in effect, defendants who did not yet exist. And therefore, if the court holds that there is no power to grant such relief, then unless it carves out in some way a distinction for cases of threatened trespass, then that decision is wrong. And there have been a couple of later High Court decisions where courts have similarly followed that approach. Lord, just two final brief points. One, maybe more by a clarification than reply. I hope you'll forgive me. It's a point Mr. Buckpitt would like me to make. It's in relation to the application to amend in the court below. My Lord, as the court knows, there was no formal application to amend the claim form. But the court was asked to amend, if need be. And we have 2 references there. Just for my Lord's note, it's supplementary bundle, page 341, and then supplementary bundle, page 349, paragraphs 23 to 26. And within that latter part,
Those are the post-hearing submissions.
my Lord, they were.
Yeah.
And the second ones were requested as a result of an email from the judge's clerk.
Yeah.
And it was provided, and it was said within that, paragraphs 23 to 26, if we need to make a formal application to amend, please tell us. Now, I accept there was no N244, but this was a hearing that proceeded on the one day, and then there was a number of exchanges with the judge, which he was perfectly content with. The only point I make is that when those submissions were filed, the claim remained on foot because of the earlier stay. And the 4 months only ran out 6 weeks after the hearing of the summary judgment application. So the claim
Ran out 6 weeks.
6 weeks after, yes, sometime in mid-March. Now the judge himself took no issue with the absence of a formal application to amend and dealt with it. Just the unfortunate thing about it is that because of the time at which judgment was handed down, the 4 months had passed. But the appellants they were alive to procedural issues. They did ask for amendment. They did say they'd make a formal application. And they did also say, if the court is concerned about procedure, we are perfectly happy to reserve, do whatever you want to ensure that the procedural matters are regularised so that injunctive relief can continue. Just sorry, I made that point. Lord, the final matter is I understand that the members of the court have also been given not only the written evidence but also the video clip. I don't know if any members of the court have the opportunity to view that. I'm grateful. All I would ask is before judgment is delivered that the court considers the video clips, in particular those in the November-December 17 period, which is why we were here at that time and why we're here now. I'll just turn my back, please. Well, I think that the final point that Mr. Hubbard would like, Mr. Babby would like me to make is that just to make the point that in AFSAR, the terms of the defendants were in the same form as our original description, i.e. not by reference to any wrongdoing.
Right.
Which we accept. We accept as too wide, but anyway. But of course, that formulation, yeah, anyway.
All right. We're extremely grateful to all counsel, and particularly grateful to you, Mr. Robinson, once again for your assistance given to us. We will consider our judgment in this matter, and we will distribute them in the usual way in advance of handout for correction, of grammatical and textual reasons only. Any further submissions to be in writing. We don't wish to have any further oral submissions unless we ask for them. Thank you all very much.
Can I make one application on my own account? Would it be possible to have your Lordship's email address so that I can ask for a reference formally for the Attorney General's A-panel competition? I'm in this awkward position of having to grovel for references every time I appear in the court. So if I could have your clerk's email address, I'd be much obliged.
The first time I've received that application in open court, but yes, of course.
Yes.